Hello and welcome to our new recording on legal reasoning. And today we are going to discuss fundamental rights, especially the right to freedom of speech and expression. I am Dr. Manvendra Kumar Tiwari, and I am teaching at the Dharmshastra National Law University, Jabalpur, as an associate professor in law. Starting with our discussion on freedom of speech and expression as a fundamental right, we see the right to freedom of speech and expression mentioned under Article 19(1)(a) of the Constitution of the marginal note of the provision. Marginal note is the uh, is the that portion of a written law which tells us as to what the provision is about. So the marginal note of the provision says, and this is 19(1), protection of certain rights regarding freedom of speech, etc. 19(1)(a). And in 19(1) it says all citizens shall have the right to freedom of speech and expression. So this is categorically mentioned in Article 19(1)(a) that all citizens shall have the right to freedom of speech and expression. One important thing to note here is that the freedom of speech and expression as a right is available to citizens only and not to persons who are not the citizens of India. Unlike Article 21, which we will see next, 21 provides for right to personal liberty, right to life and personal liberty. And the right to life and personal liberty is also available to non-citizens apart from citizens. Okay. Whereas the freedom of speech and expression right under the Constitution is only available to the citizens of India. Moving ahead, yes, this freedom of speech and expression is always to be understood in line with Clause 19(2) of the Constitution of India, which provides for the grounds for reasonable restrictions which can be imposed on the right to freedom of speech and expression by a law. So, as per Article 19(2), a law may put reasonable restrictions upon the exercise of right to freedom of speech and expression. And it mentions the grounds which the law may refer to or the law may rely upon in order to limit the extent of freedom of speech and expression as a right. So we'll read what is mentioned in 19 clause 2. It says, nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes. So what we have to see here, that that our 19(2) is actually referring to laws that were already existing at the time of commencement of the Constitution, or any law which may be made in future after the commencement of the Constitution, that is 26 January 1950. So both these set of laws, what they may do, now such laws may impose reasonable restrictions on the exercise of the right conferred by the said subclause, that is 19(1)(a). Okay. So freedom of speech and expression can be reasonably restricted by a law on the following grounds, as 19(2) says, in the interest of sovereignty and integrity of India. So this is the first ground which the law may take in order to restrict the extent of free speech as a right. The second ground is the security of the state. So the security of the state is the second ground. The third ground is the friendly relations with foreign states. And the fourth ground is public order. And the fifth ground is decency or morality. And the sixth ground is contempt of court. The seventh ground is defamation. And the eighth ground is incitement of an offense. So these are the 8 grounds mentioned under Article 19(2) which a law may use in order to restrict the extent and ambit of the right to freedom of speech and expression. Okay, what the law says, that the restrictions so imposed on these grounds must be reasonable restrictions. Reasonable restrictions. So the extent and ambit of the restrictions would therefore become important. So the courts and even the lawmakers will have to always try to strike that delicate balance between freedom of speech and expression and a law which is meant to curb freedom of speech and expression. But what is important is that the purpose of law should not be to curb free speech. The purpose of law should be to protect the interests, and the interests are identified. These 8 interests that have been identified here. The purpose of law must be the protection of these interests. In doing so, that is, in protecting these interests, a law is permitted to put reasonable restrictions on free speech. So that is therefore also an important test to determine the legitimacy of such laws. The law should not be to prohibit free speech. The law should be to protect these interests. And in doing so, the law may put restrictions upon the ambit and extent of free speech. If that is what the law is doing, at least the courts, while interpreting the correctness or the legitimacy or the constitutionality of such laws, will not draw adverse inference against any such law. Moving ahead, so we'll see a few passages, and these today we'll discuss 2 passages on Article 19(1)(a) and its relationship with laws under Article 19(2). And both these passages have been taken from the earlier question papers of the common law admission test in the legal reasoning part. So we're starting with the first passage. So this is on online defamation. So what the passage says, in India, the legal landscape surrounding online defamation is a subject of significant interest and debate. With the rise of social media and online platforms, cases of online defamation have become increasingly common. Defamation refers to making false statements about someone that harm their reputation. Online defamation includes defamatory statements made on the internet, including social media, blogs, forums, and other online platforms. Now, before we move further, we must keep in mind that even though the Constitution of India started operating from 26th January 1950, and at that point of time, internet or online content was something that was unheard, not known even to the framers of the Constitution. But one unique thing about laws and the Constitution is that laws are always drafted in generic sense, and therefore the generic words that are used in law are sufficient enough on many occasions to even be made applicable to situations and circumstances which may not have been within the contemplation of the framers of the law when the law was being made. And that is why, despite the fact that when Constitution of India, especially Article 19(1)(a) or 19(2) was being made, something like internet or online defamation was not known to the framers of the Constitution of India. Yet, because of the generic choice of the words used in these provisions, even these provisions can be applied to internet and online defamation. So there is no requirement per se that because the framers did not contemplate internet as a phenomenon, and that is why it would be wrong or inappropriate to apply constitutional provisions made without contemplating the phenomenon of internet to circumstances which are related or governed by internet. That is not the correct argument. If the words are broad enough, which is the case with 19(1)(a) and 19(2), the 19(1)(a) and 19(2), both these provisions, as is the case with laws in general, can be made applicable to the phenomenon of internet as well as online defamation. So that is one important thing that we must keep in mind, and we should not be confused by the fact that how come a law being made at the time when internet was not heard of be made applicable to the phenomenon of internet. That is certainly not the case, so long as the text, that is the words of the law, permit such an application. The fact that internet as a phenomenon was not known to the framers of the Indian Constitution will not prohibit the application of constitutional provisions to the internet or online defamation issue. Now, moving ahead in this passage further reads, one critical aspect of online defamation is determining the liability of intermediaries, such as social media platforms or websites. So, intermediaries are social media platforms or websites for defamatory content posted by the users. Section 79 of the Information Technology Act 2000 provides a safe harbor for intermediaries, stating that they are not liable for third-party content if they act as intermediaries and follow due diligence in removing or disabling access to the content once notified. However, determining whether an intermediary has fulfilled its due diligence obligations can be complex. The Indian judiciary has been actively interpreting this provision. One significant case is the Shreya Singhal versus Union of India, in which the Supreme Court clarified that intermediaries are required to act upon a valid court order or government directive for content removal, not upon private complaints though. The court also emphasized that the intermediaries should not take a proactive role in monitoring content, as this could potentially infringe on free speech. While the law provides a safe harbor, it does not absolve intermediaries from their responsibilities. Online defamation cases often involve a balancing act between the right of freedom of expression and the right of reputation. The Indian legal system requires a careful examination of the content, context, and intent of the statements to determine whether they qualify as defamatory. Additionally, the plaintiff in an online defamation case must prove that the statement was false, damaging to their reputation, and made with a degree of fault, such as negligence or actual malice. Now, these were the questions asked in the common law admission test based on this passage. The first question was, what is the primary focus of the passage? We'll see the options. The rise of social media in India, that is not the focus. The legal aspects of online defamation in India, this appears to be the focus. C, the role of intermediaries in online content. Importance of free speech on the internet. Now, B and C appears to be close, but we have to see which one is the most appropriate answer. So, the role of intermediaries in online content is the entire focus of the passage is not on role of intermediaries. The focus is more on the legal aspects of online defamation, which covers the role of intermediaries within its fold as well. And that is why the correct answer is option B, the legal aspects of online defamation in India. Moving on to the second question asked, what is online defamation as described in the passage? So option A says making harmful statements about someone in person. B, false statements made on the internet that harm someone's reputation. This appears to be correct. Option C, online harassment. No. D, a form of political activism. Clearly, option B is the right answer. Third question. What is the significance of Section 79 of the Information Technology Act 2000 as mentioned in the passage? It defines defamation laws in India. No. It provides safe harbor for intermediaries in case of online defamation. Appears to be correct. It regulates the content on social media platforms? No. It allows private complaints against online defamation? No. So clause B, option B is the right answer, because section 79 provides safe harbor for intermediaries so long as they are exercising due diligence, as is the mention in the passage. Option B is the right answer. Question number 4. According to Supreme Court in the Shreya Singhal versus Union of India case, under what circumstances should intermediaries act in response to content removal? Upon receiving a private complaint? No, strictly prohibited. Upon a valid court order or government directive? This appears to be right. Option C, proactively to monitor content? No. Only if the content is found to be defamatory? No. So clearly option B is the right answer. Upon a valid court order or government directive, the intermediary should act in response to content removal. Question number 5. How does the Indian legal system balance the right to freedom of expression and right to reputation in online defamation cases? By favoring freedom of expression over reputation? No. By favoring reputation over freedom of expression? No. By carefully examining the content, context, and intent of the statement? This appears to be right. By absolving the intermediaries of their responsibilities? No. So clearly, option C is the right answer. Sixth question. In an online defamation case, what must the plaintiff prove about the defamatory statement? Option A, that it was political activism? No. That it was made with good intentions? No. Option C, that it was true and intended to inform the public? No. Now all three are ruled out, so clearly option D, that it was false, damaging to their reputation, and made with a degree of fault. So clearly option D is the right answer. Question number 7. What is the role of intermediaries in the context of online defamation cases? To actively monitor and censor content. This appears to be right, though we'll have to see other options also. Option B, to act upon private complaints for content removal? No. Option C, to completely absolve themselves of liability? No. D, to encourage online defamation? So all clearly this is also wrong. So option A, to actively monitor and censor content, will be the right answer. So this concludes the questions which were based on this passage. We'll now move on to the second passage, and this is also a passage taken from the earlier examinations of the common law admission test in the legal reasoning part. And this passage, this is also based on the right to freedom of speech and expression and the reasonable restrictions under Article 19, Clause 2 of the Constitution. Now, we'll go through the passage first. So the passage says, the Editor Guild of India. Editor Guild here means group, conglomerate, or an association. So the Editors Guild of India, editors are associated with news media. So the Editors Guild of India has expressed concern over the draconian provisions. Draconian is within inverted commas, and that's why this is a statement attributed to Editors Guild, and this is not a statement of fact as given in the passage. Okay, Editors Guild of India has expressed concern over the draconian provisions of the Press and Registration of Periodicals, that is PRP Bill 2023. Bill is the earlier version of a legislation which is presented in the Parliament or the state legislatures for approval of the Parliament and the state legislature, and only when it is approved and subsequently gets the endorsement of President in case of a union bill, and the endorsement of the governor in case of the state bill, that it becomes a law in the form of an act or legislation. So the bill, here we are talking about a bill, that means a bill for a law which is yet to become a law. So the Editors Guild of India has expressed concern over the draconian provisions of the Press and Registration of Periodicals Bill 2023 that can have an adverse impact on the freedom of press. The Guild added, within inverted commas, Editors Guild of India would like to would like the proposed bill to ensure that publishing of news in India remains free of encumbrances and intrusive checks on publishers by the registrar. Okay, so registrar is here is a government authority under this law, which has been given the responsibility to primarily ensure the enforcement of this law, and will move further in the passage, and that the primary emphasis of the registrar and the PRP remains registration and not regulation. Okay, so they are saying it should just be for the registration, and the registrar or the law must not regulate the news media, as the latter has the potential of restricting freedom of press. Now, what is important to note here is that the Constitution of India does not provide for a separate constitutional protection for the freedom of press. So it is the generic provision of right to free speech and expression, which is also applicable when it comes to the freedom of press. Okay, so the yardsticks for individuals' freedom of speech and expression and that of the freedom of that of the press remains the same, and the press also derives its right of freedom of speech and expression from Article 19(1)(a). Therefore, the press is also subjected to the laws that can regulate free speech as per Article 19(2) of the Constitution. Reading the passage further, in the definition section, the term. So, definition section is a section in the bill. The term specified authority gives power to the government agencies beyond the press registrar conduct the functions of the registrar, which would even include police and other law enforcement agencies. Given the intrusive, expansive, and vague nature of the powers that the bill in any case allows to the press registrar, the power to further delegate this power to other government agencies, including law enforcement agencies, is deeply distressing, the guild said. The statement says Section 4(1) and 11(4) allows the registrar to deny the right to bring out a periodical and cancel the certificate of registration of a periodical to persons convicted of terrorist act or unlawful activity, or for having done something against the security of the state. Okay, so what we have to keep in mind, that conviction is required when it comes to the allegation of terrorist act or unlawful activity, and conviction is not required when it comes to for having done anything against the security of state. But done, again, it would require evidence of truth, proving that somebody has done the act. So mere accusations will probably not suffice for the registrar to exercise the powers here under Section 4(1) and under Section 11(4). Interestingly, the PRB Act 1867. Now, there was an old act which the new bill intends to replace. Interestingly, the PRB Act 1867 had no such provisions. Even the liberal and arbitrary use of UAPA, which is Unlawful Activities Prevention Act, which is the basis for defining terrorist act and unlawful activity, as well as other criminal laws, including sedition against journalists and media organizations to suppress freedom of speech. The guild is deeply concerned by the introduction of these new provisions and the way they can be misused to deny the right to bring out news publications to persons who are critical of governments, it said. Among the other worrisome provisions listed by the guild is Section 6(b), which gives power to the press registrar as well as any other specified authority to enter the premises of a periodical to inspect or to take copies of the relevant records or documents or ask any questions necessary for obtaining any information required to be furnished. Okay, now this is an extract from the Telegraph, which the Common Law Admission Test or the CLAT Consortium has taken while framing questions based on this passage. Now, coming to the questions which were asked on this passage, the first question, The PRB bill defines newspapers to mean a periodical. Now, sometimes the questions may add things to the passage, and this question appears to do that because the passage does not talk about periodical, loose folded, or newspapers. So the PRB bill defines newspapers to mean a periodical of loose folded sheets usually printed on newsprint and brought out daily or at least once in a week, containing information on current events, public news, or comments on public news. Who among the following is covered by the definition of the newspaper? Mr. X publishing news content on digital media. Not right. Why? Because clearly says usually printed on newsprint. So digital media will not be covered. Mr. Y publishing some books containing comments on the public or public news. No, books are not periodicals. Mr. Z publishing news content in print media on weekly basis. This is covered by the question. All of the above. All cannot be right. So therefore, option C is the right answer. Who among the following is not eligible to publish a periodical as per the bill? Mr. A convicted of waging war against the government of India. Conviction, and it is an activity against the state. So option A appears to be right. Waging war is a prohibited, is not only prohibited, it is an offense under the Bharatiya Nyaya Sanhita as well as under the Indian Penal Code, the erstwhile version of the substantive criminal law of India. So therefore, waging war is an act against the security of state, and conviction is there. So therefore, there is evidence of having done the act. Option A appears to be right. We'll see further options. Option B, Mr. B accused. Accused are not, as we have seen. The charge has to be proven. Option C, Mr. C accused. Again accused. Option D, all of the above. So clearly, option A is the right answer. Which of the following is a threat to the freedom of press in India? Liberal Use of Unlawful Activities Prevention Act against journalists refrains journalists from tracing, tracking, and publishing investigating articles because they apprehend that they might be linked with criminals. Appears to be true. Clause B, use of sedition laws against the journalists under the guise that through their articles they are promoting hatred and exciting disaffection against the government. Levy of GST in newspaper. This is not at all referred in the provision. Option D, A and B. Yes, clearly. So option A and B both are right, and therefore option D is right. So this is also, that is why it is also very important that you read all the options. Okay. If you would write option A to be correct, despite the fact that option A is correct, your answer would become incorrect because you left out option B. And that is why, while answering a question, all the options must be read, despite the fact that you may have found the answer before reading all the four options. So in this case, in this question, option D, both A and B is the right option. The PRP bill defines specified authority to mean a district magistrate or collector. Again, this is not defined in the passage, but the question is adding to the passage. The PRP bill defines specified authority to mean a district magistrate or collector or such other officer as the state government or as the case may be, union territory administration may by notification specify. The PRP bill is criticized by the Editor Guild of India because the definition of specified authority is too wide and can include even officers below the level of collector. The bill enables the specified authority to perform functions of press registrar, right? The PRP bill confers various powers on the press registrar general, including the power to register, deny registration, cancel the registration, etc. It's also correct. The PRP bill enables the specified authority to enter the premises of a periodical for inspection. This is also correct. So option D, all of the above, is the correct option. Option D. Fifth question, freedom of press is not specifically guaranteed under the Constitution of India, but is implied in Article 19(1)(a). This is again, in a way, an addition to the passage, but we have discussed while reading the passage that this is actually the case under the Constitution of India. That is freedom of speech and expression. Therefore, the freedom of press is part of. Therefore, freedom of press is part of fundamental rights. Options. Freedom of press being a fundamental right, no law can be made for registration and denial of registration. Clearly wrong. 19.2 is very much alive, even when it comes to freedom of press. Option B, fundamental rights are not absolute rights and reasonable restrictions can be imposed on the exercise of fundamental rights, and therefore laws such as PRP bill can be enacted. This appears to be correct. Freedom of press being a fundamental right, journalists and press is exempt from the operation of general criminal laws of the country. Absolutely wrong. Option D, none of the above. So clearly option B is the right answer. So moving on to the last question probably on the passage that was asked in the common law admission test held earlier. PRP bill denies the right to publish periodicals to a person who has been found to have committed a terrorist act and has been convicted by a competent court in India. Which of the following is most appropriate reason? Okay. The right to publish a periodical is denied because criminals do not possess any fundamental rights. Any fundamental right. This is not correct. So this would again, in a way, require the knowledge of law. The correct understanding is that even criminals do have some fundamental rights, and that all their fundamental rights are not extinguished just because they have been that the charge against them, a criminal charge against them, have been proven. So option A is not right. Option B, the right to publish a periodical is denied because such a person is threat to the society and nation. Okay, we'll have to see this. This may be right. Option C, the right to publish a periodical is denied because they may not be neutral in reporting and may incite violence and spread disaffection against the state, being themselves involved in the terrorist act. So option C is right. Why? Because all of the above cannot be correct. Option B and C appears to be right, but then among these two, we can only choose one. So C is most appropriate response compared to B, and that is why option C is the right answer. That is, the right to publish a periodical is denied because they may not be neutral in reporting and may incite violence and spread disaffection against the state, being themselves involved in terrorist act. Now, this is important because this is not straight away being taken from the passage. This is an implied understanding of the prohibition that is there in the bill as given in the passage. So that is an implied reading of the possible reason behind this ban. So option C is the right answer. So with this, we have come to an end for this recording, which was on right to freedom of speech and expression. Thank you very much. See you in the next recording.